indicates that they asked Mr. Campbell, the neighbor who said he was intimately familiar with the house, about what was there. So we know what is there, but we don't know, there was no questioning about what else might have been there that might have been taken.
But couldn't I easily argue the other side of that, and that being the state put on its case, it's your job to poke a hole in it. So if you think the officers didn't do a sufficient investigation, the state put on a case that, hey, nothing was taken, or it appears that nothing was taken. Isn't it your job to then ask the questions that you're asking, like, okay, Mr. Campbell, what was in the house? What did you think might have been taken?
It is our job to do that, but I'll go then to the state's response brief. What it isn't our job to do is the state argued when they addressed our sufficiency argument, said that we argue that Mr. Campbell was not the intruder, but we point to nothing that indicates that there was another intruder.
Right, and that's not your job to prove someone else did.
Correct.
I agree with that.
That goes essentially to the very heart of reasonable doubt, that after hearing all of the evidence, that there's something that will not let the mind rest easy. And that's probably the most concerning thing about this case, is that unlike some of the cases that I pointed out, people had familiarity or evidence of their presence in a place where they ought not to be. Mr. Campbell was in a very common situation in that he was at his parents' house, which there would probably more likely than not be evidence, especially since he told me he was there, and he was an only child and an only heir to their estate. So that, in and of itself, in the context of this case, which we must look at it, that looks like something, but is it enough to get to reasonable doubt? And we argue that it's not.
Well, but we got to stack some things on top of one another, obviously, as well.
True.
So what about his odd behavior of, for lack of a better words, reaching out to his ex-wife, who he hadn't seen in 13 years, to let her know, oh, I'm leaving on this date. Like, they've never spoken in 13 years.
And that's the third thing. And this case is, this is a very fact-intensive case. But to that point, so they go to the MXPX, or the military store, and he makes a comment to his wife that he's leaving on the 28th. Well, it may seem odd until you read further that when the police called him later, he told them that he left on that date. So he may have told her, and it may have been weird, but that's a third thing about the state's evidence.
But he had her paged at the PX. Sorry, my allergies have kicked in. I mean, it's not like he just ran into her and said, hey, I'm leaving in the morning. He made a really overt effort to have her paged. He hadn't talked to her in 13 years, and then all of a sudden, oh, hey, good to see you. I'm leaving in the morning.
Well, yes, that may be in that context, but again, if he was frank enough, he told the police the same thing. So
well, of course he did, because that's his alibi.
Well, yeah.
I mean, that's what he's trying to set up, an alibi.
Well,
so of course he's going to tell everybody he runs into, hey, I left at this time, because that's his alibi.
Well, but his alibi places him, if he left at 7 a.m., that doesn't clear him with the coroner. So there's no point if he said, well, I maybe left the 27th, and then the newspapers aren't there, which the neighbor testified Mr. Campbell always came down and checked his newspapers. But that's the third class of evidence that the state was looking at, is Mr. Campbell's motive, and particularly his motive as a not likable person. His behavior after his parents were deceased, the police testified that in their opinion, he showed no emotion at the funeral. He was someone who abandoned his wife and child in infancy and had very little contact with them. I think the son's testimony at the sentencing hearing was probably stronger than train smoke, that he didn't like him, but...
Well, and so, you made this statement, and I'm going to throw it back at you a little bit. This is a very fact-intensive case.
Yes.
Whose job is it to look at the facts and make a determination?
The jury.
Right. And so the jury took all this circumstantial evidence, which you poke holes at, and I understand, and they said, that's enough for us to believe that this guy did it. At some point we have to just say, hey, the jury, I may not have done that if I'd been on the jury, but those 12 who listened to those witnesses and saw the proof said this is enough for us. You know, where's that line of us going behind the jury on a facts? It's very, as you said, intensive fact question.
It is, and the line is twofold. It's the standard that we apply on appellate review, which is rational trier fact, and it's the standard that they held themselves to, which is not absolute certainty, but moral certainty, and something that would let them, after reviewing all the evidence, let their mind rest easy that they knew that they had their person. And that's the biggest problem with this case. This is a man who had familiarity with the house, was acknowledged that he was there. They found there were a number of different red herrings. The sheets in his car that he said he didn't take, but they...
What about the dog being locked up and those kinds? I mean, that the dog normally would go crazy if someone that didn't know came in the house, and the dog was fine until the police showed up. I mean, I get that this is a completely circumstantial case, but you
Yes.
start building the bricks. At some point in time, you have to say, hey, look, the jury was rational thinkers, and it's enough, even though we may or may not necessarily agree if we'd been on the jury, but we weren't.
Well, the bricks lead up to a certain point, and I would argue that that point that they reach, and that I've just mentioned about the state, is that the takeaway from this case is there could have been someone who did it, but Mr. Campbell there's nobody else that was investigated. There was nothing that was, well, there's firearms, there's this clock, he's an unlikable person, but...
You keep going back to the no one was investigated, and then I'm going to be quiet
Okay.
and let you argue more. But, you know, again, I don't disagree with you that they have to try to eliminate, you know, to a point. But again, there's that line that at some point in time that's on the defense to point out, hey, police officer, did you interview Mr. Campbell? Did you do this? Did you do that? Did you do, you know, and point out to the jury they didn't do those things. And if that's not there, it's not, the state doesn't have to, in order to meet their burden, also say, hey, by the way, we didn't do this, or we did do this. They put on their case the way they see fit, and it's the defendant's obligation at some level to poke those holes to create that doubt.
It is, and we would argue that it was enough. The case is essentially the evidence that was presented at trial was the evidence that was collected in 2010. There was nothing else. I don't know what prompted them to do the investigation that many years later. That's kind of, I guess, a thing to have in the back of the mind rather than an evidentiary issue to consider in terms of the sufficiency. But the problem with this case is as I think the trial attorney, and I'd have to go back to my brief, in closing, there was what is not there as often as telling as what is there. You know, when you talk about if you're painting a face, the shadows are just as important. But investigating, well, there were guns there. Were there other guns that were taken? The motive that they presented for Mr. Campbell, that they found a statement in his home that had credit card stuff on it. It's not this court's job to investigate the status of credit card debt in the United States, but that's not. Her name, the mother's name was on the credit card statement. It had charges indicating that he'd used it. All of it gets to that point that it's like, at what point is this just a dysfunctional relationship, and what point does that transition to, I'm going to kill my parents while they sleep in their oxygen masks in the back of the head and the front of the cheek? And that's the dilemma that happens in this case. I'm out of time, and I may address the Wilkerson factors if this court has any questions about it.
No, I do have, though, one last question about that.
Yes, sir.
His statement was that they were awake and walking around, yet they were found in bed in their oxygen masks. Another disconnect between his version of the events and the facts as presented.
That's correct.
Okay.
That's correct. And the time of death was placed between 6 a.m. and 6 p.m., so I don't know at what point they would have been up and dressed. But I'll cede the time to the state. Thank you.
No. Good morning, Your Honors. May it please the court. My name is Garrett Ward. I'm here today on behalf of the state in the matter of State versus William Roger Campbell. Your Honors, this court, or this case presents with three issues: sufficiency, an evidentiary claim, and sentencing. We'll speak briefly to this evidentiary claim. The state does agree that there was not proper authentication of certain cell phone records that were introduced at trial. There was no sort of records custodian affidavit introduced, and no records custodian testified. The state does contend, however, that the admission of these records was harmless, and I'll touch on that briefly now and really get more into that as I go through the state's strong case when I address sufficiency. But in sum, this cell phone records evidence is simply that this defendant, who was I believe an 81 or 82-year-old man at the time of his death, didn't use his cell phone on January the 28th. In and of itself, that's already not that unusual. It's particularly not unusual considering the introduction or considering the rest of the cell phone records that demonstrate that on numerous other occasions, Mr. Bill Campbell,
So does that really make any fact in the case more or less probable?
I mean, it has some tendency to, Your Honor. If the cell phone record showed that on, at 1 p.m. or at 2 p.m. on January the 28th, Mr. Bill Campbell's cell phone was being used to, play Candy Crush or browse the internet, something of that nature, that would certainly speak to his being alive.
The fact that he wasn't using his phone during the window in which the coroner said he was killed doesn't really make it more or less probable that that's when he died, based on the fact that the records also show that he went days without using his cell phone.
Your Honor, it's certainly not perhaps this sort of concrete case that demonstrates, or this concrete piece of evidence that demonstrates time of death. There is certainly other stronger evidence in this case of time of death, which does speak to harmlessness. But just in terms of the relevancy of this evidence, it does have some tendency to make the time of death identified by the coroner and spoken to by, the medication log and the paper not being sort of appropriately dealt with on the 28th. It tends to confirm that time of death theory, at least in some respect. And I take, Judge Dyer, I take your questions to go to relevancy. That's sort of this low threshold for admission. Any tendency to make any fact more or less probable, I'd suggest to this court that this certainly clears that floor. But regardless, even were this court to decide that perhaps this evidence wasn't relevant, it would still be harmless for all the reasons that the state has laid out in its brief. Harmlessness via erroneous admission for relevancy or authentication. The harmlessness analysis is the same, and this evidence would be harmless, or was harmless. Turning to sufficiency, Your Honors, I think I largely agree with my friend on the other side that there are sort of three pillars of the state's case here. There's opportunity evidence, there's sort of motive evidence, and then there's the evidence that suggests that the sort of possibility of a burglary doesn't really add up. As for opportunity, I think that's relatively straightforward. We know that the defendant was in and around his parents' home on the 27th of January and on the morning of the 28th. I don't think there's any serious dispute about that. As for the defendant's motive, there are almost two sub-pillars to this part of the state's case. There is sort of the pre-murder and the post-murder evidence that really together do establish motive here. First, there is this evidence found in the defendant's home that he is in some amount of credit card debt and that he is to some degree financially dependent on his parents. There's evidence.
So, yes, there was credit card debt. What shows that he was dependent on his parents for that? How many, again, it's not our job to go out and look, but I bet a whole lot of people have $25,000 credit card debt in the U.S. these days, unfortunately.
Yes, certainly, Honor, and I'm not trying to make any representations about the proclivity or not of
just how is that tied to motive when that's all we really have?
Well, first, Your Honor, I would say that's not all we have here as far as financial dependency. There's, I believe there's an envelope found either in the defendant's car or in his home that indicates there was a cash loan extended to him. But also this credit card evidence shows not just mere credit card debt, but that there's a line of credit that I believe is drawn from his mother's Chase bank account that he's making charges on. So we don't just have sort of a bank statement that said William Campbell owed some money. What we have is evidence that showed William Campbell was receiving money directly or indirectly from his parents. And you know, that on its own, maybe that is just a single brick. And I largely agree with opposing counsel that there are a lot of bricks in this case, and that viewed individually, none of those bricks is a sort of a shutdown case. None of them is a silver bullet. But when you put them all together, a rather complete building is formed by the state's case, and this evidence of financial dependency is sort of but one layer of these bricks. Your Honor is also speaking to sort of post-murder behavior showing some level of financial strain. The defendant moves really rapidly to reduce his parents' estate, which he's the sole heir of, moves really rapidly to reduce it to cash. Within about 2 weeks of their death, he's selling this rare grandfather clock to...
So I get that, but if he's the sole heir, and I don't mean this disparaging, obviously, but he's not the most well-informed, let's say, that individual, and he knows, hey, all this is mine now, so I'm going to get some cash and put myself in a better position, doesn't necessarily mean he killed him. I mean, he may not, just because he didn't know how you got to probate the will and you got to go through all that or this, that, and the other, he's like, hey, these are my parents, I'm the only person, that grandfather clock's now mine, and I don't need it, we're going to sell it anyway, might as well sell it now so I can pay a couple bills that I've got.
And maybe I don't live here and I don't want to leave this valuable asset sitting in the home.
And Your Honors, if the state's case was just that he sold some of his parents' assets within a month of their death, we probably wouldn't be here. We probably wouldn't have gotten past the jury stage, and I'd be singing a very different song to this court. But that's not all we have in this case. Again, this is one brick, is his behavior after the murder. Sure, on its own, that brick doesn't conclusively demonstrate guilt, but that has to be considered with the evidence I've previously mentioned to this court. It also has to be considered along with, I guess we're really here getting to the burglary pillar of the state's case. There is, I believe, in the basement of the victim's homes a busted window, and any evidence or suggestion that there was an intruder in this house, that there was a burglary, which is sort of the only other avenue that was considered in this case was perhaps an intruder. The evidence of that really stops there. The rest of the evidence throughout the house demonstrates that there was no burglary. Judge Dyer, you noted that there is a lot left in this house. Not only is there a lot left in this house, the things that are left in this house are perhaps the things that would be most likely to be taken in a burglary, that would be the easiest to sort of immediately get financial gain from. There's a few envelopes of cash sitting in plain view that aren't collected. There's at least one handgun that is out in the open. There was testimony at trial that handguns are sort of the number one target for these sorts of home burglaries because they can so quickly be reduced to cash.
Did they make a determination as to probably what kind of weapon was used to shoot the victim?
I believe it was a .25 caliber pistol, Your Honor. That's my recollection from the record. If I'm mistaken.
No reference that he had ever had such a gun, or that the victim had a gun like that in the house that was ultimately missing.
My recollection of the firearms in the house is that there was a .25 caliber pistol, I believe, in a gun safe in the basement. The combination for that safe was sitting on a business card, either in the basement or in the kitchen of the home. So there was such a weapon in the home. The other ballistic evidence does suggest that they were killed with the same that the two victims were killed with the same weapon. That's really as far as we've got here.
Doesn't it also suggest, and I did get confused in reading the briefs about this, was there not a suggestion also that the bullets used could have been the bullets that were from the house?
There are some loose bullets of that caliber, Your Honor.
Okay.
So we
But it wasn't proven that the bullets that the victims were killed with actually matched the bullets.
That's
in the
that's
house.
my recollection.
It's just the same caliber.
That's my recollection of the record, Your Honor. So we do have all of these items that would perhaps be the number one targets for a potential burglar. They're still in the house. So that doesn't really add up for, a burglary gone wrong being what happened here. We then have to consider the defendant's odd behavior, both pre and post murder. I'll first speak to post murder. The defendant says to law enforcement that he left sort of in the morning of the 28th, that he got up. I think he just says he talked with his parents as they got up and walked around in their bed clothes. Specific that, well, we didn't eat breakfast or anything like that. Didn't go outside, get the paper. And then we find these two victims wearing oxygen masks in their pajamas, lying in their beds, suggesting not that they were walking about their home, but that they were asleep and they were killed in their sleep. What also has to be considered is the defendant's behavior with respect to his ex-wife. And Your Honor, there's no word for this other than odd. What I'm speaking, of course, is this exchange that happens at the defendant's ex-wife's workplace on the 26th of January. Estranged is rather an understatement for the relationship between the defendant and his ex-wife. He hadn't seen her in well over a decade, didn't really speak to her. On the 26th of January, he goes to her place of work, pages her to the front of the store just to tell her, hey, I'm not going to be here in a couple of days. Again, this is a woman he hasn't spoken to in a decade. I have no explanation for why the defendant would have done this other than to start crafting some sort of alibi about, hey, early in the morning on January the 28th, I'm going to be out of town. Your Honors, what the defendant's trying to do here is establish from a source that isn't necessarily friendly to him, establish from this source that he's gone on January the 28th, then he wants to stage the scene to make it seem as though this death occurred at a time where he would have been gone. And I'll acknowledge, Your Honors, that he didn't perfectly craft this alibi. The time of death evidence suggests that even by the defendant's own accounts to his ex-wife and police, he may have been at the house. But it's not necessarily the overall success of this attempt to craft an alibi that is the most important thing in this case. It's the effort itself. It is such an odd action, and there is so little explanation for this action other than trying to establish that he's not going to be there at the time he wants it to seem like his parents have died. So, Your Honors, what we have in this case is just brick after brick after brick after brick. We have his financial motive, his actions to reduce the estate to cash, his odd behavior with respect to his wife, the overall unbelievable nature of this potential staged burglary. No evidence that anything specifically was taken, and affirmative evidence that the number one targets for burglaries are in plain view and left at the home. We have evidence of time of death at a time we know the defendant would have been in and about the home. Looking at all of these bricks together, the jury could easily conclude that the defendant was the perpetrator of this crime. As this court's well aware, and Judge, you alluded to, we in the state of Tennessee task juries with looking at all these bricks and essentially deciding whether or not it makes a building. And they did that in this case, and this court shouldn't disturb their determination. I'm happy to answer questions either about the evidentiary claim I addressed earlier or the consecutive sentencing determination.
I've got some questions about the sentencing.
Sure.
It seems to me, in looking at the trial court's ruling on consecutive sentencing, the trial court focused solely on the fact that there were two victims in two separate rooms. And that's how he reached his Wilkerson factors. I mean, the trial court says this wasn't one event. He was in one bedroom, then he moved to the other bedroom. The two victims weren't shot in the same location. The first victim was murdered in one room, and then there was a time period between that and the second victim was shot, and then basically says that meets the Wilkerson factors. How does that meet the Wilkerson factors? Especially when the law is very clear that the fact that you kill two people doesn't necessarily mean that you get consecutive sentences for that action. So I'm struggling with how he met the Wilkerson factors here.
Certainly, Your Honor, and I'll agree, Judge Dyer, that just the simple fact that the defendant killed two people absolutely doesn't establish a case for consecutive sentencing. And I think that's what the trial court's trying to explain here. Maybe not in the most artful manner, which of course is not what Wilkerson and sort of its subsequent cases demand. They don't demand the most artful and elaborate sentencing findings. What the trial court is trying to explain is that this isn't just a case where a defendant shows up and kills two people sort of in quick succession or in one event. That we have a deliberative process that leads to the defendant creeping into one of his parents' rooms, not in the middle of the night, but while they're still asleep, and shooting them in I believe the first victim was shot in the cheek. Leaving that room, having time to step away from this course of action, and instead choosing to double down, to enter the second parent's room and shoot that parent in the back of the head. And Your Honor, what I think that speaks to, obviously it speaks to the severity of this offense, the defendant's adherence and escalation of his course of action does make this offense more severe. And I think it also speaks directly to the need to protect society, which is the other finding under Wilkerson.
But none of that was said or articulated on the record. So, I mean, we can't really speculate from about one sentence, of what the trial judge said, that's what he really meant, can we?
Well, Your Honor, I characterize the trial court's findings as a bit more than a single sentence. We have roughly 3 pages of findings here and some of that is just laying out what Wilkerson demands, to be sure. But what the trial court says is he discusses facts for some period of time, probably a lengthy paragraph is my recollection of the sentencing hearing transcript, about the circumstances of this offense, the nature of creeping into one room, shooting one parent, leaving, walking down the hall, creeping into the second, and shooting the other parent. And then the court does immediately after that reference both Wilkerson factors. Your Honor, I think it would be relatively easy for this court to say these are the facts that the trial court is talking about, then directly says because of that, Wilkerson finding A, Wilkerson finding B. We do know what the trial court was thinking here. We don't have to guess. The trial court explains it not in the most, lengthy.
But here's what the trial court says. So he gives the paragraph where he cites the statute and cites to Wilkerson and says, this is what I have to find under Wilkerson. And then the very next paragraph, so the court finds that based on the fact that the first victim was murdered in one room, and then there had to be time before the second victim was murdered in a separate room, that given the severity of the crime and the complete disregard for life for both victims, that consecutive sentences are necessary to protect the public.
Yes, Your Honor.
You're saying that's enough under Wilkerson to impose consecutive sentences?
Yes, Your Honor. I believe that it is.
What's he protecting the public from?
Well, I believe he's protecting the public from the sort of the type of person like the defendant that would engage in the course of action he's just identified. What the trial court is saying there by describing, not in a novel the length of War and Peace, but by describing the crime and what happened and why this is different from just, I hesitate to use the term everyday run-of-the-mill double murder, But why this is different, the trial court is explaining why in its view this is different and suggesting that that meets both findings under Wilkerson. Under the standard of review that this court applies to consecutive sentencing, it's placed its reason on the record. It has identified facts. This court should affirm its determination. If there are no further questions, the state would ask that you affirm. Thank you, Your Honors.
So, Your Honors, just 2 points. And first, I would thank the state for stepping in this argument, because it did not, was not the person who wrote the brief. And I want to say that before I make this comment. But Judge Dyer, it was a very, very long case, and appreciate it. One, there were 2 types of .25 caliber rounds found in Bill Campbell's room, Federal and I believe Remington Peters. They never found the firearm, to my knowledge, but said that that when it was tested at the TBI, both of the rounds were shot from the same firearm. Never found the firearm. They did identify one of the shell casings as having the same tool mark as the other rounds that were in the pack in Mr. Campbell's room. So one was matched to those, and one was not. And to the point about the Wilkerson findings. So, one, we would argue that the trial court's findings were not up to par for what was required for Wilkerson. Judge Dyer, as you said, the trial court basically said this was a deliberate act that was done by one person. There was time to reflect, and then the person moved to the other person and killed them. For Wilkerson, what is required is findings on 2 things. One, it reasonably relates to the severity of the offense. And if it was just a premeditated double homicide where you killed elderly people while they were sleeping, that could be it. But the other prong is reasonably necessary to protect from the public. And to that point, if the court does uphold the convictions in this case, the record shows that Mr. Campbell went basically 20 years before the offense, 30 years before the trial, with a very sparse criminal record. And I believe it's maybe 1 or 2 passing bad checks in Oklahoma or something to that effect. But what's most important is that from 2010 to 2011, Mr. Campbell had absolutely no criminal charges. And that completely blows out of the water the fact that he's any kind of risk to the public. If he's gone 11 years after he supposedly killed his parents without having any kind of criminal behavior, then that shows that he is not a danger to the public. And thus, that prong, at least of the Wilkerson factors, is not met, even if the court...
And I'm really not trying to be cynical here, but he also, by committing this murder, we can assume, maybe we can't, we can assume he became in a better financial position than he was before the murder. So, maybe the reason he didn't kill anybody in those years is because he wasn't in debt. But if he gets in debt again, who's to say he's not going to kill somebody again to make money?
And that might have been a consideration if he'd been tried the year after. But when he's gone 11 years and not done anything, and I believe the estate was maybe between $180,000 over 11 years, I think we're at the point we can say that behavior is that's not, the public's not in danger. Thank you, Your Honors. We would ask this court to reverse and vacate on the conviction for the murders, for the first-degree premeditated murders, and either reverse and remand or reverse and find under de novo review that the Wilkerson factors were not met and impose a single sentence run concurrently for both of the murder charges. Thank you, Your Honors.
Thank you.
Thank you. All right, Madam.
Yep, good. All right.
Madam Clerk, would you call the next case?
Jimmy Moats versus State of Tennessee.